Please be seated. Good afternoon. Welcome to the Appellate Division, First Department. As I call the calendar today, please ask for the time you actually need, and remember that if the panel has additional questions past the time you've been allotted, we'll ask them and you'll have an opportunity to answer. We read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you have asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know how much time you are requesting. People v. Layton.
Respondent 6.
Okay, I'll give you 6 and 2 and 6. Carboni.
The respondent requests 4 minutes, Your Honor.
I'll give you 4 and 1 and 4. Ray is submitted. Solorzano versus Lopillo. Lopillo.
Appellate 5 and 2. Respondent 4.
5 and 2 and 4. Vasquez versus Manhattan College.
Your Honor, appellant 8 and 2, please.
Your Honor, respondent has 4 minutes.
Give you 6 and 2 and 4. JDS Construction versus Copper Services.
Your Honor, 6 plus 2. Respondent, Your Honor, 6 minutes.
6 and 2 and 6. Cropper versus New York City Transit Authority.
Appellant 6 and 2, please.
Respondent 5 minutes, please.
Give you 5 and 2 and 5. Werner versus Jag First Avenue. Are you the only one here?
I'd like to appear to the extent that I guess I would just say 5 minutes or less.
I'll give you 3 minutes, and if we have more questions, we'll go on. People versus Jonathan Alonzo. 6 and 1 and 5. Cordayan versus Kassir.
6 for the respondent, please, Your Honor.
6 and 2 and 6. McGovern versus St. Luke's Roosevelt.
Appellant 5 and 2, please.
5, 2, and 5. Board of Managers versus SGN 443.
10 and 4. And 10 for respondent.
I'll give you 7 and 2 and 7. Nah versus Cohen. Submitted. People versus Eva Garcia. Submitted. And the last one, Corsani v. Financial Industry, is submitted. Come on up on People v. Layton. Please proceed.
Good afternoon, Your Honors. May it please the Court, Clara Hammond-Oakley on behalf of Appellant Leighton Ryan. Your Honors, courts have uniformly held that anonymous tips, like the tip in this case, are one of the weakest possible justifications for the stop of a person, and thus they need to be supported by significant indicia of reliability. Such indicia of reliability did not appear here, and so the stop of Mr. Ryan was unlawful.
Well, you rely heavily on Brown, but wasn't there more information available to the police in this case than there was in Brown?
Your Honor, I believe that if anything, the description in Brown was more detailed, as it described what the person in the bodega was wearing, down to, I think, the hat and color of his clothing. It also specified, actually, who had committed the crime. In the case of Brown, specified that there was a man who had a gun. And additionally, when the police arrived at the scene, there was, in fact, a man at that exact bodega. So we're not just talking somebody near that bodega, but somebody who was actually exactly there.
Well, you had the 911 caller who was the actual victim, alleged victim, and said, "I'm bleeding, and I was just shot by these people. They're in a black Mercedes." You know, that's a lot of information.
So, Your Honor, a lot of that information comes from the call itself, and
White Mercedes, pardon me.
sorry,
Please, never mind.
Comes from the call itself, and the prosecution did not rely at all on the content of the call at the hearing. The prosecution did not raise any of the information from the call that they raise now on appeal, such as the caller providing the name of Brian or this information about bleeding or anything like that, either at the hearing or in the extensive written submissions that they submitted to the court afterwards. Nor did anything about the content of the call form the basis of the court's opinion in this case. And I would just like to very briefly address the prosecution's contention here that this was a partially identified call. That argument is wholly unpreserved. The prosecution never raised that below. And in addition, the trial court found affirmatively that this was an anonymous call. In the court's decision, the court has a header that says anonymous call. They describe the 911 caller who could not be identified. And so the court is not only barred from reviewing the anonymity of the caller based on the preservation issue, but also a LaFontaine issue, in that that was not decided adversely to Mr. Ryan and so is not reviewable on this appeal. What we have here is a wholly anonymous call. We have nothing that was argued at the hearing about the content of the call that lends it any credibility, any reliability.
The victim was never ID'd by the NYPD, correct?
Yes, that is correct. They were never able to contact
What
him
about
again.
the fact that there was also, I mean, I understand about the anonymous nature of the call, but that there was also indication that the caller did say he knew where the people lived, and when they were stopped, one of the officers looked at the license and it was the address. Isn't that another piece of evidence the officer could have relied upon?
Yes, Your Honor. However, that lends absolutely no support for the stop. When, at the time that the car was stopped, the officer obviously hadn't seen the driver's license. That information hadn't come over dispatch, and so that lends absolutely no support for the stop. Additionally, even after the stop, all that information does is increase the tendency of this tip to identify a determinate person. It does absolutely nothing to support the allegations of criminality here. It is very important to understand that there was never any other evidence that a shooting had actually in fact occurred. The prosecution stated in their brief that the Mount Vernon Police Department was investigating a shooting. That's a misreading of the record. What the record shows is that the NYPD actually called Mount Vernon and told Mount Vernon, we have a report of some shooting that happened at some time somewhere in your city, and the Mount Vernon did not have any other information to provide. Not only was there no shooting ever actually shown or suggested outside of this tip, but it was affirmatively undermined by the fact that there happened to be an NYPD patrol officer posted at the exact location where the shooting was originally presumed to have occurred, who said, there's nothing going on here. He said, no shots fired here, there's nothing going on here. And while I realize that, of course, that doesn't prove that a shooting didn't happen, it certainly undermines the tip to some degree. Just like in Moore, how the tip originally described a dispute involving a gun, and the Court of Appeals in that case said when the police showed up, and there was a minute later and there was no dispute going on, that calls into question the reliability of that tip. Here we have even more direct questioning of that reliability, in that there was an officer at the actual scene, at the place, and said, this tip isn't panning out in real life right now. Your Honors, nor are there any other of the indicia of reliability that courts have looked for in these kinds of anonymous tips. The tip did not predict any future activity. The police did not observe anything independently supportive of criminality before they stopped Mr. Ryan's car. All they had was temporal and spatial proximity to a tip, matching a vague description. And the prosecution cites many cases where that's enough in known informant cases where the police officers either have somebody who's giving their name, putting their credibility on the line, putting themselves at risk for prosecution for false reporting if it is a false report, or are speaking to somebody face to face and can judge from their demeanor how reliable they are, whether or not this is an excited utterance, a present sense impression, something like that. There are absolutely no cases supporting the contention that that is enough in an anonymous tip case. And in fact, all of the anonymous tip cases say quite the opposite, because in Moore, in William II, in JL, and even in Argyris, there are temporal and spatial proximity and description are not enough. The courts look for much more than that.
Thank you. You have time in rebuttal.
Good afternoon. May it please the court, Larry Glasser for the respondent. Your Honors, in this case, I do believe there's a valid waiver of appeal, but before I address that, I'd like to respond to a
Yeah, I
few.
wouldn't belabor that point, counsel.
Okay. Addressing the points that counsel made. First of all, whether we label this an anonymous tip or not, I mean, that was not litigated at the hearing. That was not argued between the parties. The fact of the matter is, this court in People v. Dumit, D-U-M-I-T, People v. Hall, said that a 911 caller giving their first name and the 911 system recording their callback number means that the informant was not anonymous, and it gives the information reliability. That's not the same as a anonymous person walking up to a police officer on the street, saying something and then walking away where they're in the wind and can never be tracked down again. So putting aside the label of it, this court has ruled before in 2 separate cases that this type of information is reliable by the virtue of someone giving their first.
Of course, as we've noted, the victim was in the wind, remained in the wind, was never identified by the NYPD.
Well, the record wasn't clear, and it wasn't really an issue in the hearing of exactly what measures they took. They tried to call the victim a few times, and they couldn't, and he didn't answer at that callback number. But, I mean, that could have to do with what efforts they put into it, and that really doesn't affect whether in the first place the information is reliable or not. But to address one of the first things Your Honor said, this information did have a very detailed description. And I would add, by the way, first of all, the 911 call in the case was in evidence. I know in the case, Appellate in their brief says it's unclear, but in the beginning of the hearing, the ADA turned over, I think it was a compact disc, and stipulated to its admissibility. The court said, I'll accept that in evidence, not I'll accept that and mark it for identification. They said that's defendant's A in evidence. Later in the hearing, the defense played, admittedly, the radio run, but from that CD, and they didn't lay a foundation. They didn't seek to move the CD into evidence. The CD was in evidence, and they played one file from it. So the 911 call was in evidence. It was before the court. And in the call, it's clear the caller says his name is Brian. He says he was shot in Mount Vernon. He knew the home address of the person, and he described the shooter being one of 2 black males in a white Mercedes near to, he said.
Counsel, the recovery of the gun came in what seemed to me rather strange circumstances, that you're in a Mercedes, which apparently should have rather well-designed glove compartments, and somehow he was able to see between the seam, between the door of the glove compartment, and also smell gunpowder.
Yes.
Is that plausible?
Well, Your Honor, first of all, the court found that to be credible, and the court is entitled to a lot of deference in finding credibility or making credibility determinations. In this case, Your Honor, and if I may, I'll address this later, but I think the stop of the car and the validity of the stop is separate from the validity of the search of the glove compartment. By the time the officer lowered the door of the glove compartment, and clearly there may have been something wrong with the hinge or something like that, but he did not unlock it. He did not take the key and open it. He was able to pull the door down enough to see the gun and smell the gunpowder inside. By that time, Your Honor, he knew the address that was reported to 911 of the shooter matched this defendant's address. This defendant was one of 2 black males in a white Mercedes.
How is that anything other than a generic description? The victim recognized the individual as one of 2 black males.
Well, there's a lot more than that because, again, the fact that this was in the Bronx when the victim said he was shot in Mount Vernon, this defendant had already told the police he came from a baby shower in Mount Vernon.
What does that have to do with the description of the defendant?
Well, I think the description when it came over as 233rd Street and White Plains Avenue, 2 black males in a white Mercedes, the evidence at the hearing was within 1 minute and less than 1 block away, the police car saw, or the police officer saw 2 black men in a white Mercedes driving, again, within a block, within a minute of receiving the radio run, driving in the opposite direction, driving away from that location. I think, frankly, they would have been derelict not to just pull the car over. But then, before they did the search, they learned that the defendant had been in Mount Vernon. They obtained the defendant's driver's license. They learned that it matched further information provided by dispatch that the victim had been shot in Mount Vernon. The victim provided the shooter's address, which matched. And I'll add as well, I think that there isn't, in addition to having probable cause to conduct the search they conducted, they did have the defendant's consent. And we know that consent is based on what's objectively reasonable and what the person thinks they're consenting to. What's important in this case, Your Honors, is I submit the police officer didn't ask to search the car. He asked, do you have anything in the car we should know about? And the defendant said, no, you can check. And I think it's obvious and it's objectively reasonable that what the police want to know about are weapons, are guns, are drugs, and contraband. So when the defendant says you can check, he's given consent to check everywhere in the car that a gun could be. The police didn't remove the door panel. They didn't cut open the upholstery. They didn't even unlock the glove compartment. They lowered it through because of some defect in the hinge or some damage to the locking mechanism. They were able to slightly lower the door without opening the glove compartment.
Didn't he also say that he smelled gunpowder when he opened the when he went into the car? So he said he saw something around the edges of the glove compartment, and also that he could smell gunpowder.
And I was about to say that, Your Honor, because in response to Appellant's point, I think the smell of gunpowder also is corroborative of the 911 call, because unspent ammunition doesn't smell. But when a gun is fired, when a gun has been discharged, you can smell the burnt gunpowder. So the smell of the gunpowder further corroborates the 911 call, not just as to the identity of the individual involved.
Thank you, counsel.
But that a crime occurred. Thank you very much.
So, Your Honor, that last point was exactly the kind of faulty reasoning that the trial court used as well. This supposed smell of gunpowder, the officer did not observe until well after the stop and until after the search, until after he pulled down on what he knew to be a locked container until he created a gap large enough for him to peer through. So that can in no way be used to corroborate the tip when the officer was acting earlier upon it. As to the anonymity of the call, it's not true that it wasn't litigated. The defense counsel said that this was an anonymous call. The prosecution didn't argue with it, and the court accordingly found that it was in fact anonymous. DeMitt and Hall were in very different procedural postures in this case. In those cases, this court was upholding the lower court's decision that the call was not anonymous or was only partially anonymous. So obviously that was something that the defendant was appealing. That was a decision that was adverse to him or her. And this court was saying, no, that was a fine decision for the court to make. Whereas opposed to what we have here, where the prosecution didn't even raise those arguments below, the court decided in Mr. Vine's favor, and so it's simply not reviewable here on appeal. In terms of the details that were given in the tip and whether or not the 911 call is in evidence, I agree that the record is confusing about what exactly was and was not in evidence. The prosecution stipulated to the admissibility of the CD, however, it was not formally moved into evidence by defense counsel or the prosecution. One radio run was played, and at one point the court said that's in evidence. However, it's not clear. The bottom line is, though, that the prosecution never made any arguments about the 911 call below. If the prosecution had made those arguments about the name or about exactly what was said on the call, defense counsel would have had plenty of things to say about this 911 call, about why the contents of this 911 call rendered it wholly unreliable and made this case exactly the kind of malevolent tipster trying to weaponize the police to carry out a grudge that courts since DuBois have been worried about. However, defense counsel did not raise those arguments because the prosecution never brought it up.
Thank you, counsel. Thank you both.
Thank you.
Carboni versus Alfa Romeo. Please.
Good afternoon, Your Honors. This case involves the denial of a motion for summary judgment made post-note of issue under 3212F in a case where the defendant was a company that didn't come into existence until more than 20 years after the plaintiff's last alleged exposure.
No, we're talking about successor liability, right, counsel?
There was no pleaded claim of successor liability.
And there were other car companies mentioned in the complaint, and I'll ask the other side about this, that were alleged to have successor liability.
There was 3 other entities that were specifically identified as the successor to another entity.
Right. But on the other hand, your client didn't answer the standard form interrogatories that are required in NICAO, which is done for everybody. Judge Mendez knows that well. I know it well.
And I know you wrote the CMO, Your Honor, but the CMO says that,
I didn't write the CMO. I revised the CMO.
revised, I
I
apologize.
take credit for everything.
I know you're very familiar with it. But the CMO says that they don't have to be served if the defendant has already appeared in NICAO. There's no showing that the client here, Alfa Romeo FCA US, ever appeared in NICAO before. And further, even if that was the case, the plaintiff filed the note of issue. They never
But
raised a single objection.
You litigated this case for a couple years, you appeared at depositions, you asked questions, and didn't raise this issue until several years later, once the plaintiff had filed a note of issue.
We did ask for a dismissal based on lack of any product identification more than a year before we moved for summary
You
judgment. Well
asked
before.
like in a conference, or you asked in a motion?
There's a procedure to request a voluntary dismissal if you feel there's no basis for the claims
Yeah,
against
but
your
that's called a nose jam, right? Isn't that? It's a no ops summary judgment motion.
Yes.
And you asked for one of those on the basis of inadequate product ID, not on the basis of the status of the defendant.
With the status of the defendant was that it didn't make those products, so it was inadequate product ID.
You didn't say you named the wrong defendant in the nose jam or in your request for a nose jam.
Well, we don't actually know what defendant. We weren't saying the name of the wrong defendant. We're saying the defendant that you named. It's not our job to litigate their case for them and to investigate who they should have sued in the case. We have to defend our client's interest. We were named in the case. We didn't come into existence until 2009. We didn't make those products. They didn't even plead a successor claim against our client.
How would permitting the discovery that's sought here prejudice your client's rights?
Well, beyond the fact that I think it was waived by filing the note of issue, we would have to answer, I believe it's over 90 interrogatories, and many of them have numerous subparts. They don't have a single viable theory of liability against our client other than they speculate it may be the successor to an entity that they haven't even identified or named. And they didn't bring up that theory until we moved for summary judgment post-note of issue. At some point, the plaintiff has to litigate their claims.
Counsel, this is Judge Mendez. Who would have that information as to which is the entity that somehow that is a successor to the Alfa Romeo entity?
So our
Who
client,
would have that information?
I mean,
Possibly
perhaps
your
the,
client?
excuse me?
Possibly your client may have that information?
I don't know that FCA US would have that information. They began distributing them in 2014, which was 5 years after they came into existence. But it's really plaintiff's burden. And that doesn't give a basis for liability. And it's also, the
Might it
case
give a
was
basis for
certified as
discovery
trial ready.
is the question. I mean, that, you may, at the end of, after discovery's been exchanged, you might get out scot-free. I don't know. But why shouldn't they be able to seek the information from you, and then you can answer?
And the other thing was the denial was just in its entirety without any leave to renew, which under F is, I don't think is the proper method of denial.
Thanks. You got some time in rebuttal.
Thank you.
Thank you, Your Honor. Alani Glansky for the
So,
plaintiff.
counsel, you did name those other car companies and say, and any successor entities. Why didn't you do that for Alfa Romeo?
Yeah, apparently we knew the successor relationships and the entities for those. However, the standard complaint, which is incorporated into this complaint and this action, states expressly that the defendant shall apply, the named defendant shall apply to all predecessors or successors in interest, and standard discovery requires disclosure of purchase agreements and all sorts of other information that implicates successor relationships.
You had submitted interrogatories and asked them to respond to them
Yes.
sometime prior, and they never did. Is that
Yes,
correct?
they never did. They said these were irrelevant, but while ignoring the fact that successor and predecessor questions are explicitly in the standard discovery questions. Standard discovery allows the parties to get to the bottom of which entity is responsible or whether substitutions in the name should be made.
Well, sir, so how then do you respond to your friend's point that by filing the note of issue and representing that all discovery was complete, that you haven't waived any rights you had to that information?
Yes, thank you. On that point, that waives issues that are apparent in the action, such as, you know, if you're trying to prove the nature of an accident or a fall and you don't have the information and you nevertheless, as in the cases we outline, and you nevertheless file for a trial conference, trial readiness, and a note of issue, then you've waived. But here, where they answer repeatedly over a 2-year period as the entity named in the complaint and don't raise any objection that they've actually got a different name, and when they hold themselves out to the world commercially in the name used in the complaint, then this constitutes a surprise when they file a summary judgment motion following the filing of the note of issue. Not only that, CMO Section 21 states that no summary judgment motion can be filed at all until discovery is complete. And here, obviously, they were explicitly refusing to comply with any discovery, and so discovery wasn't complete.
And counsel, isn't it true in the ecosystem of NICAL that summary judgment motions are almost always filed after a note of issue, and often frequently beyond the time period provided in the CPLR? It's often done.
Yes, but when an entity refuses to disclose any discovery at all and doesn't comply at all in any possible way with standard discovery, which is what allows the action to proceed, then that's a different question. And filing this, you know, but we don't necessarily have to rest on the fact of whether the summary judgment motion was properly filed. There's not a basis here for actually granting summary judgment, and Justice Silvera was correct in saying that litigation by surprise is not what affords you summary judgment in this case. Alfa Romeo accepted service as Alfa Romeo. They filed a verified answer as Alfa Romeo. They filed a second verified answer as the same name without objection. They appeared at the plaintiff's deposition on 3 dates under the same name, remaining silent even as a co-defendant said, hey, you sued us under the wrong name. They said nothing. And then they proffered their no-op SJ form under the Alfa Romeo name. And finally, there were 2 other co-defendants, co-workers, deposed at a much later time and close to the filing of the summary judgment motion, at which the defendant also appeared under the name in which they were sued and raised no objection.
Right, and another counsel, was it for Porsche, came and said, hey, you named my client incorrectly, let's talk later, we'll stick to changing the name in the caption, right?
Yes,
that
Your
happened,
Honor.
That happened in front of the Alfa Romeo.
Simple name change, and name changes are routinely allowed under the CPLR.
Okay, thank you, counsel.
Rules. Thank you, Your Honor.
Okay, you got a little bit of rebuttal.
And just to respond, I think this is part of the confusion before the trial court. We're not raising any defense under the fact that they sued them under a misnomer.
Right.
If you correct the misnomer, it's corrected to FCA.
No, you made that point very clear, yeah.
And there's no liability there, so it's unclear how they were deceived. It's also unclear.
It's just that they say that it sent them off on the wrong path, or it made them think there wasn't a path that they should go down because you didn't make that change.
It is the trade name. It's just the company that uses that trade name doesn't have the liability. They also sent a process server to a gigantic building on Chrysler Drive that has a giant Chrysler logo on it, and they're pretending they don't know who they served, which is a little bit confusing to me. And just regarding the discovery, after counsel had appeared in the case, they sent the product identification interrogatories, which are 2 very short document demands that just say, we're your products that you manufactured at these sites. They sent them directly to the client. They never sent them to counsel. They never followed up with us until after the summary judgment motion. The answer to that would have been no and no because we didn't exist. The standard discovery was post-note of issue, post-summary judgment motion filing. That's the very first time they ever asked for those. And we said, we've already made the motion. And we tried to negotiate it. They wouldn't hear it.
All right, counsel, thank you very much.
Thank you, Your Honor.
Solorzano v. Lohijo. excuse my accent. Please.
May it please the court. My name is Nicholas Calabria. I represent the appellant Gotham Air, the plaintiff's employer in this case. The motion for summary judgment by the defendants was granted for contractual indemnification and failure to procure insurance against Gotham Air.
Yeah, speaking of the insurance, did you make that argument below affirmatively that, yes, we complied with it, here's a certificate of insurance, we did it? Did you make that argument below or only now?
No. In fact, the policy of insurance is in the record, so it was present in the court below.
And the policy of insurance, does it name, remind me, does it name explicitly?
No, it has an additional insured
It just says if you enter into a
by
contract with
endorsement. So,
someone, they're going to be additional
yeah,
insurance.
if there was a written contract obligating Gotham Air to procure insurance for the defendants, that policy would have
And
provided
is that
coverage.
considered appropriate under the law as being, making sure that they're named as additional insureds?
Yes.
So
That's
you
the
made that,
typical-
you made that argument.
Yeah, that's
below.
the typical way that additional insured issues are typically presented in this court. There's a standard form by written contract, and if there's a written contract, which we are contesting in this case, and additionally, they'd never even put any evidence that they asked the insurance company for the additional insured coverage. There was no tender letter, there was no disclaimer. There's just an affirmation by counsel saying they didn't get the coverage and that the defendant's own insurance company was representing them. But there's nothing in the record that even says that they asked the insurance company for additional insured coverage.
Could you address the validity or not of this particular contract that was in effect in this case?
Sure. The defendants brought in a Jacob Shaffrin who could not testify at all about the contract documents that were involved in this case. The representative from Gotham Air testified that there was a written proposal that for working at Bel Air, and that they had worked for Bel Air on prior occasions.
So this was like a standard, there was a sort of
Well-
form contract that they...
Well, what it was a document that was undated. It was noted as a letter or sample agreement. There was language in it that it was a document that was supposed to be incorporated into the contract, which it wasn't. And it was signed by Mr. Solomon, but it was undated. And in the questioning of Mr. Solomon at his deposition, they said, is this the type of document that you would usually? And he said, yeah. But there was nothing about, was this document, this hold harmless, part of the contract that you were working there on the date of the accident? And it was never asked. So when they made a motion for summary judgment, they still had a burden to demonstrate that this hold harmless agreement was part of the contract for which Gotham Air was working there the day of the accident.
So they were relying, at least in part, on Mr. Solomon's testimony that, yeah, this is the kind of document we usually use.
Yeah, and again, they had been there, they'd been working at this building before, and all they said that this was the type of document that they would execute.
But he also, didn't he admit that he put his initials on it? And
Yes.
signed it, and I mean, that's a
But
fairly affirmative
It might have been
act.
for another job before this, it might have been for another job after this. No one connected it to this work. And they have the burden to demonstrate that. And if this testimony is the only proof they put in, you know, I believe that it has not been established prima facie that they demonstrated that there was an obligation to indemnify or procure insurance. And I cite to the court, this court's Padron versus Granite Broadway Development case and Dwyer versus Central, that they have the burden to demonstrate that this document is part of the contract, and it was not done in this case in this testimony. They could have gotten an affidavit from someone at the defendants and said this document was part of that proposal for the work that was being done that day, but they didn't do it. And on this record, they haven't met their burden of proof.
Okay, thank you. You have time in rebuttal.
May it please the court, David Pasternak for respondents. First, Your Honors, I think the record is clear that there was a meeting of the minds here. The, Mr. Solomon, who was the principal of Gotham, did testify when asked that his company had done work for Triumph, not for Belclair. There's no testimony that he had done work for Belclair.
Triumph was the parent corporation?
Triumph is the managing agent for these various properties.
Okay.
They had done work for Triumph at other locations, but there was no testimony that he actually done work for Belclair before. But he acknowledged that back in March of this accident happened on September 25th of 2019. In March of 2019, Gotham had forwarded a proposal to Belclair through Triumph. And in response to that proposal, he was forwarded this whole harmless agreement to sign, which he said he was very familiar with because in every instance where Gotham did work for Triumph, he was provided with this sort of hold harmless agreement and this agreement to provide additional insurance. And that it was his understanding that he couldn't do any work at the location unless that agreement was signed. And the agreement was signed. And he was asked at his deposition, assuming the proposal, which was dated March 12th of 2019, and assuming the first invoice provided by Gotham was provided on March 18th, 2019, which what the record indicates, does that mean that you would, when you sign this undated, it's undated, we acknowledge it's undated, but the courts have held that the mere fact that it's undated in and of itself is not controlling. And in fact, the courts have even indicated if an agreement is provided that isn't even signed, but if there's external evidence that there was a meeting of the minds, that agreement itself, in that situation, would be enforceable.
Did you put in any testimony from anybody from Triumph that knew about the status of this contract? Because Mr. Shafran wasn't familiar with it. Was there anybody else that testified on your client's behalf?
No, Your Honor. But Mr. Solomon.
So you're relying on Mr. Solomon's testimony?
There seems to be a meeting of the minds between Mr. Solomon and the respondents in the case. There isn't a meeting of the minds between, I guess, the insurance company who we're seeking indemnification from, and through Gotham. There seems to be a lack of meeting of the minds there. But regarding the actual principles, there seems to be no dispute.
Thank you, counsel. Would you like to speak, use your remaining 30 seconds to talk about the insurance?
I mean, was there a tender? Was there a tender made to Gotham to represent them? I mean, he's saying no, there never was.
My understanding is there was a tender. There was just no response to the.
There was no response.
Yeah.
It was not that, oh, we don't have insurance, we're not doing it. You just made no response, so they started to represent themselves,
Yes.
assuming maybe that you didn't have the insurance.
They represented themselves. It's a separate insurance company. It's the insurance company that insured Lopijo Realty and Belclair Hotels provided the defense of those defendants, the respondents in this case.
Any other questions? Thank you, counsel.
First issue, page 313 of the record, Mr. Solomon specifically testified and was asked if this was the first job for Belclair Hotel, and he said no, it wasn't. So it wasn't Triumph. He said Belclair. The tender issue, there's no tender in the record, okay? We have affirmation from counsel saying that there was a tender. I do not represent the insurance company. I represent the insured Gotham Air. I don't have any knowledge of a tender. They had a burden of proof of demonstrating that there was a failure to procure insurance. How did they do it? An attorney's affirmation. No good. And I put in the the additional insured endorsement, which is in the policy. So if there was a valid written contract in this case, there would have been additional insured coverage. I just want to, again, focus on the testimony of Mr. Solomon. And again, it's not just the way he answered, it was the way he was asked the questions by counsel. And I have that in my brief. When they asked him about the undated sample letter, they said, have you ever received this type of document before? Well, why didn't they ask him, is this the document that, that you signed to work on this job for this date? It was never asked.
Well, look, they can ask him whatever they want to
Right,
help
but
their case.
they wind up with bad questions and answers, and they can't rely on that to prove that there was a written contract, in this case, obligating Gotham Air to procure insurance and indemnify the defendants in this case. And again, when we put in the opposition to the motion, they still didn't produce an affidavit from anyone at the defendant that would say this undated letter agreement was the document that was attached to this proposal for the work that was being done at the date of the accident.
What about the meeting of the minds? Do you think that there was a meeting of the minds, that this was
Definitely
the deal
not.
that they had
It was
struck?
just that this was the type of document that he said, I don't understand this document. He said, but yes, whenever I had to come work, they would make me sign this document, just like a document like this. They kept asking, is this the type of document that you would
Counsel,
sign?
you made that point. Thank you.
Okay. Thank you, Your Honor.
Thank you both. Vasquez versus Manhattan College. Please.
May it please the court, William O'Connell for the defendant, appellant, third-party plaintiff, Manhattan College. Your Honors, this was a renewal motion, and it's the appellant's argument that renewal should have been granted, and there's triable issues of fact in this case.
Should the court have exercised its discretion in the first place to allow the 2018 document in? I mean, in other
Should the
words,
court
I know
have-
you say yes. I know you want.
Yes.
Of course. You're saying, like, in your reply brief, you say the world is not perfect. But, like, you still have to have a reasonable excuse for, like, why you didn't put it in the first place.
You do have to have a reasonable excuse, Your Honor, and I understand my adversary reasonably claims, well, where's the contract? This contract, if you look in the record, was the 2019 proposal. It was 2 pages, and this employee left not too long after these events. So
So did you indicate you lost the 2018 contract? You just couldn't find it in your records anywhere? Once Mr. Ryan left?
That's correct. That's what the general counsel of Manhattan College put in her affidavit, that we could not find it and we could not contact him. Obviously, we have it in our law firm all the time where we're told that we have to save all our emails and put them in the file for a specific case, and we do it intermittently. And you have it in an email, but you don't have it in your file. So when you go to look for something, and maybe a 2-page proposal in this instance might have slipped through. It's my position that given the discretion of the court realized that obviously we would want to produce that document. It helps us in this case, and we didn't because we couldn't find it.
Even if the court were to have allowed in this 2018 contract, didn't the 2019 contract control the area where this particular plaintiff was injured? And it was a different contract. It was a specific, I know it was a little contract as opposed to the other one, but didn't it have all the terms that control the small area of work that was being done where plaintiff was injured? So what difference would it have made even if we had the 2018 contract?
It would make a difference because the 2019 agreement was a modification of the 2018 AIA contract.
Where does it say that? Does it
Well, our argument in our brief says that it met Section 13.1, I believe, of the contract. Owner may order changes in the work within the general scope consisting of additions, deletions, or other provisions, and shall be authorized by written change order signed by owner contractor. And that's what happened here. We have the 2018 AIA contract, and it calls for, in Leo Hall, asbestos removal in the concrete lab And the same thing is in the 2019. In fact, counsel at the deposition asked a very good question, I thought. If it's the same scope of work in both of the agreements, then why do you have the 2019 proposal? And the answer was, as Mr. Ryan explained at his deposition, the process is before the thing starts, they go through to look for any asbestos, and they make an evaluation, and they make a plan and a contract. But during the job, it frequently happens in asbestos, they find something else. And they didn't know it was hot, and now they know it's hot. And that's why they have a modification provision in the contract. That's what they did here, and they addressed it, and it covers the same work. I didn't say they're the exact same contracts. I know my witness said they were separate agreements, but he meant physically they are separate agreements. But they cover, I use the word share, the same work. The same work.
I mean, I know it was was it Leo Hall? It was downstairs in the same building, but wasn't it on a different area of the?
You have an excellent memory, Your Honor. That's related to the Room 140 cluster,
Right.
But the concrete lab is in the west side of Leo Hall in the basement, which is covered in both the 2018 contract and the 2019 proposal. So I'm not saying they're perfect matches, but I'm saying they share the same scope of work. Obviously, when they were down in the area of the concrete lab, they missed something. And later on, during the job, they eventually saw it in 2019, and they said, okay, we need something here.
So let me ask you, I mean, since this whole issue comes down to the indemnification agreement, so why would you have a separate indemnification agreement in the 2019 proposal that only goes one way if there was a full indemnification proposal in 2018? I mean, how did that get
Well, it's an
messed up?
excellent question, and having been in the insurance defense field for a long time, I can answer it happens every day where there's multiple indemnity provisions, and usually the answer to that is what the answer I'm asking for here, for the court to say there's a tribal issue of fact because you have conflicting indemnity provisions here. You have a mutual one, which my client testified is our custom and practice, and the affidavit of somebody else in the college agreed to that. Or in this case, you have a very ambiguous one which says, we have to indemnify EMC for anything arising out of the work unless they're completely negligent, and then then it doesn't say anything about that, which I find ambiguous as a matter of law. It also violates the general obligations law, so it should be stricken. We shouldn't even consider that indemnity provision. But my position is there are two related. There's a modification to that contract, and they're the same scope of work, and therefore this court should find a tribal issue as to whether the indemnity obligation was established as a matter of law or really was not established as a matter of law. Thank you, Your Honor.
Thank you, counsel.
Good afternoon, Your Honors. C. Briggs Johnson for the respondent, EMC. I think I'd like to start with the second contract, Judge Kapnick, that you pointed out. It's drafted, a proposal drafted by EMC and sent to Manhattan College. It doesn't mention the original agreement. It doesn't say anything about the major renovation project that was at Manhattan College that took over the entire Leo Hall. The first project was substantially completed in a month, where it was supposed to, and this is a year later. He's insinuating to the court that this was an ongoing project, but really this is a year later. This is a whole year later. So it is a smaller project. It's in a small room. We're removing pipes, okay? So if you want to argue that it's a modification of the major first agreement, then you would assume that the second agreement would have to have express language saying
But
this
it would
is
be
a
nice if it said this modified agreement.
Right,
I mean,
right, this is-
was there any reference, I don't recall seeing it, in the 2019 proposal to the 2018 contract?
No, I read it right before I came up here. It says nothing about the first contract, nothing at all.
What about counsel's point that because of these two agreements, there are issues of fact with regard to the indemnification?
Oh, you mean the two different clauses? Well, I think to Judge Kapnick's point, the first agreement has mutual indemnity obligations, right? The second agreement has indemnity obligation in my client's favor. How does that supplement? It conflicts, so there's no meeting of the minds regarding the second agreement either, regarding the initial project. It shows a complete lack of understanding of the main agreement, or at least reference to the main agreement. The agreements do not even, remotely, I guess, correspond to each other. And I think that's the problem here. And again, it's a year later. And if I can go back to
So
the...
you're telling me that the work on the big project was completed about a year before the,
It was the substantial completion date, according to the contract and according to Mr. Ryan, was that it was supposed to be a year beforehand. And if I could just go briefly to the
and
renewal...
we know that substantial completion dates don't always get
Oh,
met.
believe, yes, of course. Of course, those dates can go on, and we don't know when it was substantially completed. But just to the renewal point, the general counsel's affidavit had no idea that there was a first agreement. She said, I understand that there was a second agreement. There was no search for the first agreement, okay? This is their agreement. They drafted it. They gave it to us to sign, okay? The project manager says, I worked very closely with Mr. Ryan. If he worked very closely with Mr. Ryan, shouldn't he have sent something in the affidavit about the first agreement, about the specific dates they tried to reach out to Mr. Ryan, about why the heck, when Mr. Ryan found this agreement, where he had it, where was it?
I think they admitted their papers were a little lax or a little light on that argument, yes.
And if you look at the cases in my brief, you have to have specific information, specific attempts to at least search for this contract, to know it existed. And you also have to, the witness who produces the information has to explain, you know, was he too busy? Was he unavailable? But again, there's case law from this department that says you got to give us something, some information. What happened? That's the renewal standard. If there's any other questions, I'll rest on my briefs.
Any other questions? Thank you.
Thank you.
Your Honor, just in relation to the point, there is no, I agree with counsel, there is no reference in the 2019 agreement, 2018 agreement. There doesn't need to be. It would have been more helpful to me, definitely.
Sure would have.
It's not in there.
But you're
and there's
claiming
no
it's you're claiming it's a modification of another agreement. I mean, I don't know, somebody would have written modification to, I mean, it just seems odd that it's.
It does seem odd, but if you also, Mr. Ryan testified that when he was asked about that, well, it was flying fast at the point, and they called me, and this is what we had to do, and he basically said that, and they said, well, also about the indemnity provision in it, and he said, well, the value of this one compared to the AIA contract was much different.
Is the record clear as to when the project was completed?
Well,
the underlying project, let me be clear.
It was not completed as of the time of the 2019 agreement. In fact, there's evidence in the record that specifically the work in the area where the plaintiff was injured was extended over a separate summer because it's a school and they didn't want to interrupt the school. So it was separated into 2 summers, and that is in the record. I don't have a page for your honors right now.
That the work on the first project was went more than 1 summer? Or
yes, absolutely. It was the work in the cellar, in the basement of Leo Hall. That work, which is the subject of both agreements, was extended into that second year so that they could complete it in a more appropriate time. Your Honor, that's really all I have to say. It's my position that there is 2 agreements here. I understand you have a first one and everybody wants to go with that. The second agreement was a modification because it was the same kind of work. And in this case, it's our position that there should be a tribal issue of fact. Thank you.
Thank you, counsel. Thank you both.
Thank you.
JDS Construction Corp. Please.
Good afternoon, Your Honors.
Afternoon.
Mark Leppelstadt for Appellant Talisman Casualty Insurance Company. Your Honors, this is a $254 million delay claim on a Manhattan construction project asserted against a surety and a subcontractor. The lower court awarded partial summary judgment dismissing any defenses regarding the issue of concurrent delays. So based on the lower court decision, Talisman, the surety, is not only responsible for delays caused by Talisman, caused by its principal, Copper, but anyone in connection with this project. So we're basically the guarantor of all.
But that's because of paragraph, I mean, how do you get around paragraph 25B, which requires 48 hours notice of these delays?
First of all, that paragraph says nothing about defensive claims. The paragraph says nothing about concurrent delays. There's nothing in there about concurrent delays. It says delays that could be excused, notice should be given, but doesn't say anything about concurrent delays, which are delays that occur regardless of whether the delays.
It's a pretty broad section, counsel. I don't know. It's a very broad section. I'm not sure I agree with you on that point. Please continue.
Yeah, so, the lower court's decision is erroneous for 3 reasons. A, the bond requires that JDS must establish that the delays were caused by either copper or talisman. They must be caused by one of those in order to recover delay damages. The subcontract provides that the delays must be caused by copper in order to award delay damages. But I think most importantly, under the common law, as reported in Manshall Construction, on a claim for delay damages for breach of contract, it's incumbent upon the plaintiff to show proximate cause of the delays by the defendants and the damages sustained. Under this court's decision, there's no requirement of proximate cause. So I don't see how the decision could be reconciled with the Manshall Construction case on the elements required to sustain a claim for delay damages. All right? We discussed the notice provision, and again, there's nothing in that notice regarding affirmative claims. Excuse me, regarding defensive claims. It's all about affirmative claims. It says nothing about the right of the subcontractor to defend itself in the face of a delay claim by the contractor.
What's your best case that supports that point of, do you have a case that supports that point that's on all fours? Because Hunt's Point is a case heavily relied on by the other side.
Yes, there's a, glad you asked that. And it's called Delmar.
I'm sorry, it's called what? Delmar?
Yeah, I'm going to find in 2 seconds. Hold on.
If it's in your brief, counsel, we'll find it. Tell us
anyway,
why you rely on that.
That's an appellate division case. And in that case, the court made a clear distinction between notices regarding affirmative claims and defensive claims. And the court held that although, yes, the notice was required for affirmative claims, there's no requirement for defensive claims. That's United States Fidelity and Guarantee Company versus Delmar. And it's pages 8 and 9 in the brief. And I just want to quote from that case. It says here, and this is the appellate division speaking in Delmar. The notice provisions which plaintiff relies upon set forth a limitations period applicable to affirmative claims by a party seeking some relief under the terms of the contract or some adjustment thereto. We do not interpret those provisions as a bar to defendant's challenge to the timeliness of the work completed where, as here, those challenges are raised in the context of defending plaintiff's legal action for payment due under the contract. That's the same situation we have here. Although, yes, granted, there are notice requirements for affirmative claims, that does not apply to the defense of delay claims asserted by the plaintiff against the defendant. And I think that case is right on point.
Are we reading the word right out of the condition preceding provision? It says right or remedy is conditioned on the 48-hour notice.
It says right or remedy, but it doesn't say anything about defenses. I think there's a distinction there.
Counsel.
And the provision that speaks to the requirement of causation is 25E. Paragraph 25E, and paragraph 25E says nothing about notice as far as us defending an affirmative claim for delay damages. So if you look at 25B, it really, the intent was to require notice if the subcontractor intended to assert a delay claim, not notice if the subcontractor is defending itself from a delay claim by the contractor.
Thank you, counsel.
May it please the court. Andrew Bourne from Cohn Ziffer, French and McKenna on behalf of the respondent. I'm going to address just a few things that was said real quick. One, the U.S. Fidelity case, Delmar case, that was just alluded to. Putting aside that it wasn't cited in the opening brief, it was only cited on reply. I think Your Honor hit it right on the head that it is clearly inapplicable here. It has nothing to do with the provision at issue in this lawsuit that was incorporated into the bond that his client issued. That provision dealt with, and I did a deeper dive into the briefing in that case, that provision required warranty claims to be brought within 1 year of substantial completion. It has nothing to do with whether a contractor can assert a defense, a waiver of defense, or explicitly waive the defense in the contract by not taking advantage of the contractual provisions to assert another party caused the delay.
But he was talking about paragraph 25 of this agreement on pages 233 to 234 of the record. I mean, that whole section 25 is all about delays.
Correct.
So is there any validity that you can see to his claim that they're only for affirmative delays, but not notice is not required if you're for defending any kind of delays?
No, in fact, as I think it was Justice Moulton who pointed out, the Hunts Point case actually explicitly held the opposite, right? I again, did a deep dive, couldn't find the briefing, the exact language issue, but this court affirmed the dismissal or summary judgment in favor of an owner against a contractor. And this court, and I'm going to quote it because I really do like the quote, if you give me 1 second. The court said explicitly, well, now I lost my page, so I apologize, Your Honors. But
In view of the contractor's undisputed failure to comply with the contractual procedures for seeking extensions of time and documenting delays, the motion court properly precluded it from claiming that it was not the cause of the delays.
Exactly, and that's exactly what we have here. That was the holding of the court below. That was so that's their first argument on appeal. Their second argument, which we didn't hear in this argument, but I'll address it real briefly. Their second argument is as a surety, they're not bound by that they somehow changed that.
Well, they say, I understand the argument to be that since it's not in the performance bond itself, it can't apply to them.
I don't think that's their argument. I think there are.
Well, that's an argument. I think
that is an argument, but
in their reply brief, they say they do not exist in the surety's performance bond, the notice requirements, and therefore, who cares about?
Well, as the precedent we set forth in our brief, and I can cite you the cases. It's in our brief. One, an incorporated contract and incorporated into a performance bond. They're read as a whole, so they are explicit. That contract is explicitly incorporated into the performance bond. Right. And the second fallback argument that they come up with, that Talisman comes up with, is that somehow using the words actual damages, canceled out the protections or that waiver of that defense. Again, that is not the law. In fact, we cite, again, to a Court of Appeals case. It's on the first page of our brief. And what the law says is that they stand in the shoes of their principal.
That's the whole concept, isn't it?
Correct. That's the whole concept. But what they're asking for, despite the parade of horribles of this is a $254 million claim, even though we know it's limited by the face value of their bond, that's the principle that they like this court to overturn. That well-settled New York law, that they actually don't stand in the shoes of their policyholder. They somehow are afforded greater defenses without doing so explicitly.
Well, let's go back to the condition precedent and whether that was triggered here. 25B talks about condition precedence to rights, to a right or remedy. Is a defense a right or a remedy?
I would think so, right? I mean, I think on the plain language, it doesn't just say...
Plain language would be right, remedy, defense. So the question now is a defense captured by right or remedy?
Well, it's any right, and I would say a right to assert a concurrent delay as a defense is a right. They are waiving that right because they did not take advantage of the plain language of the contract. Their principal did not, which is exactly what this court held in Hunts Point is okay. They said that you cannot do this, that the principal, or not, it was not a surety case, that the contractor waived the right to assert the defense that the delay was caused by someone else.
And is that consistent with the principle that conditions precedent ought to be narrowly construed?
I think so, yes, because it is, while it should be narrowly construed, it's still a broad enough provision. It doesn't just say, you know, contractor's timely satisfaction of all requirements set forth herein is a condition precedent to its bringing an action under this contract. No, it's saying right or remedy. And it doesn't have the right to assert a defense under the contract. I see I still have some time. We're going to rest on our.
You're basically out.
Okay. Well, we're going to. Then I'll sit down, Your Honor. Thank you very much.
You have time for rebuttal.
Your Honor, with respect to the Hunts Point case, one of the holdings, and it wasn't dicta, it was one of the holdings of the case, was that the losing party failed to submit admissible evidence showing other causes of delay that was unrelated to its conduct. Here, we have submitted overwhelming evidence of other parties' responsibilities for delays. Regarding the related parallel case on the same project with Parkside. Parkside was the concrete superstructure subcontractor whose work preceded Copper's work, whose delays necessarily delayed Copper's work.
No, you do a good job unpacking all of that in your papers, but the problem is the notice provision.
Right, and again, as was just mentioned, the condition precedent of the notice provision in paragraph B should be narrowly construed, and it only speaks of rights or remedies. It doesn't speak of defenses, but the defenses are clearly referenced in paragraph 25E. 25E says nothing about notice because it basically restates the common law. In order for a plaintiff to recover delay damages, they have to show proximate cause. They can't get around. You can't waive the requirement of proximate cause, and that's the essence of the plaintiff's claim here. It's a claim for breach of contract for delay damages. They can't just recover delay damages from the surety for any party that delayed this job, like Parkside, that caused 805 days of delay, according to JDS's own expert. It just flies in the face of requirements under the common law. And I think paragraph 25E basically restates those requirements, that they have to show causation. Sorry for being repetitive, but...
No worries, counsel. Thank you.
Thank you, Your Honor.
Thank you both.
Thank you, Your Honor.
Cropper versus New York City Transit Authority. Please.
Good afternoon, Your Honors. May it please the Court. Christopher Della Carpini for the appellant, Mr. Cropper. Our appeal rests on three simple premises. One, Mr. Stewart, Transit's bus driver in this horrific collision, has a judgment against him.
Which was on default because he didn't comply with discovery, correct?
The judgment doesn't say default, it just says judgment, and it's a judgment rendered after a verdict at trial. He's on that.
Didn't it happen? I'm
Wasn't
sorry.
that
He was
vacated?
defaulted.
Wasn't that judgment vacated?
You're referring to the first time this court had to deal with this case.
Yeah.
No, it wasn't. If you look at that decision, this court was very carefully to say, as limited by the briefs, it only vacated the judgment as to transit. Mr. Stewart isn't even mentioned in that first decision by this court. Whatever the reason for that.
Mr. Stewart,
So there's a
this
oh,
is
go
Judge
ahead.
Mendez. Did Mr. Stewart appear at trial and participate in the trial as a defendant or as a witness, let's say, for the Transit Authority?
He most certainly did, Your Honor. He testified at trial without ever having sat for a deposition by the plaintiff, and his testimony evidently warranted this court throwing out the judgment on appeal as to transit. And yes, Mr. Stewart was on the notice of appeal. Transit's counsel on the notice of appeal says he represents Stewart and transit, which gets to that full cooperation issue under Public Officer Law 18, which I'll talk about.
Also, I think we can all agree that there is an extant judgment as against Stewart.
Absolutely.
Okay? And so what, though, flows from that?
What flows from that is the statutory obligation of his employer transit to indemnify him against that judgment. Now, the question is, which statute are we talking about? Because
Well, it's not really indemnity, right? Because indemnity in its classic sense means that one party pays a sum of money to another, and then another provides recompense for that. Here, Mr. Stewart is not coming out of pocket to plaintiff.
not anymore, because he's assigned that indemnification right to Mr. Cropper, which we submit he's entitled to do under the general obligations law. This is a claim he had against his employer. He could have cross-claimed against his employer for indemnification if he hadn't been represented by the same attorney as his employer.
But the thing is, the decision from 2021, when you were up here in the appellate division, said, thus, the action has been unequivocally terminated against all parties. So how can we?
Well, I think the action was terminated once that first appeal was heard. We had a jury trial. We had a judgment from the jury, then we had an appellate decision on that judgment.
Yes.
That action, I get that. I get that. The second appeal is terminated on jurisdictional grounds, but I understand that. But they're not saying the judgment is no longer in effect. It's outside the record, but that judgment's still on the books against Mr. Stewart. It's out there.
But there's no cross claims by Stewart against the Transit Authority. So how are you gonna get to them?
We had to, after the second decision by this court, we had to bring this plenary action after getting an assignment of Mr. Stewart's indemnification right, which this court has never decided upon. This court's never judged the merits of the indemnification action. In the first decision, you threw out the judgment just against Transit, saying nothing about Stewart. In the second one, you said, well, the trial court no longer had jurisdiction to hear the indemnification claim. So here we are for round 3.
But no one's ever paid anything on this claim. Is that correct?
Neither Stewart nor Transit has paid. The other defendants have paid on their share of the judgment, yes.
But didn't this court find that Mr. Stewart was not negligent because he was faced with an emergency situation?
That's what this court found about Transit. But I looked at Cropper 1, as I call it. Mr. Stewart is not even mentioned in it.
But if he's the driver, isn't he Transit with regard to this discussion? If he's driving the bus?
Well, then I have to ask why this. All I can say is nothing about Stewart is mentioned in the first appellate decision. It says Transit's not liable, and it does mention that argument. There was no time to react.
Well, that's why, I mean, it was based on the emergency doctrine. That's why this court threw out the judgment that you got at the jury trial, correct? So, I mean, you know, Stewart was driving the bus. I understand he wasn't, I guess he wasn't the defendant in that case, but if there was no reason to find the Transit Authority responsible, how could there be a reason to find the driver responsible, given that he was the one that was driving the bus that faced the emergency situation?
I think where that argument leads is to an implicit vacator of a judgment. And I don't think we can do that here. I don't think this court can say implicitly, oh yeah, we meant to get rid of that judgment too. But also, I don't believe this is conventional respondeat superior. This is an indemnification statute. There is a judgment, and the employer owes on that judgment against its employee.
Thanks, counsel. You can expand on that in rebuttal.
Thank you, Your Honor.
May it please the court, Yolanda Yalla for Transit Authority. The judgment is intact as to Stewart because he was in default for failing to provide discovery after Transit was released of his counsel. So the default is not on the merits per se, it's because he defaulted with discovery. Yes, he did appear at the trial, but that has nothing to do with the fact that he defaulted in the pretrial discovery.
At the trial, he was not represented by anyone?
No, he was pro se. He came pursuant to a subpoena served by plaintiff's office.
And testified.
Correct. Transit did not represent him. Apparently, a notice of appeal did mention him for Cropper 2. Obviously, that was an error because all the briefs and paperwork were done solely for Transit. And because of the vacator, Transit cannot be vicariously liable for Stewart's actions, which were not negligent anyway. Whether you consider it under 1212 or whether you consider it under 18, there has to be a showing of cooperation. or there has to be a showing of negligence.
Well, 1212 on its face doesn't speak. The Public Authorities Law, 1212, on its face doesn't contain a cooperation provision, does it?
No, that
its
one
face.
deals with negligence.
Okay, so
But
what
we
you
re-
would like is, and you may well be right, you would like to the more governmental-friendly requirements that are contained in the Public Officers Law.
Yeah, I think we go through extensively in our brief that all these provisions are saying, essentially, we don't want you impairing indemnification. And if you look at the different statutes, 18, as adopted by Transit's bylaws, broaden the protections. The only limitation is that the employee must cooperate. And we established in the court years ago that he failed to cooperate. He flatly said, I'm not doing anything for you guys unless you give me my job back. That was established, and more importantly, plaintiff never opposed the motion to be relieved. So he can't complain now that we didn't show lack of cooperation. He was in default in opposing that motion.
So when he appeared, Counsel, this is Judge Mendez, when he appeared at trial, he did so pursuant to a subpoena on behalf of himself, not on behalf of Transit. And he testified as to what? As to the damages?
He testified as to the happening of the accident. So
The
that's
happening of the
essentially,
accident.
based upon his testimony that it happened so quickly, this court eventually agreed he was faced with an emergency situation.
But he didn't appear because Transit requested his appearance. He didn't appear to cooperate with
plaintiffs-
Transit, but
It's,
but on behalf of the plaintiff.
it's my understanding it was plaintiff's subpoena that brought him in. But he was certainly pro se at the time. He was not represented by Transit at the trial. It was his decision to appear. Just going back to, so we have 18 says you have to cooperate. He clearly did not cooperate. They waived any contention against that. If you do it under 1212, it says the employee must be negligent. We already established, this court has said, he was not negligent because he was faced with an emergency situation. So regardless of the statute you apply, of course we say it's 18 that should apply, but
Well, I noticed that in the bill jacket, in the letter from the Transit Authority weighing in on the adoption of Public Officers Law 18, Transit was concerned with it because they were. It seemed the tenor of their position on Public Officers Law 18 was that it may be viewed as diminishing some of the rights enjoyed to indemnification by their employees. And the letter said, in part, it is because we have adopted the principle of indemnifying our employees against liability they may incur while engaged in their official duties, we are concerned about the adoption of this bill. And so, doesn't that sort of support their position that their employee is quote-unquote liable under this existing judgment? And would employing Public Officers Law 18 here diminish the rights enjoyed by the indemnity rights enjoyed by the employee, then employee?
no, Your Honor. If he would have cooperated, there would never been an issue of indemnification. You know, we got to this point because he flatly said, I am not cooperating. So had he cooperated, anything he got hit for, he would have been indemnified for. And to permit an assignment that says, hey, you decide not to cooperate, I'm going to give you over $4,000 if I collect on this judgment. I mean, an assignment like that would be encouraging collusion. You know, who's to say every plaintiff's attorney will go to the driver and say, don't cooperate, I'll throw you some money on the side once I get a default judgment against them. That's certainly not what can be intended.
Thank you, counsel. Please.
Your Honors, I tried in this third appellate brief in this case to not reiterate everything that was in the second one. But in the second one, and it's referenced at page 14 in our latest brief, we make very clear it was Transit that asked to bring Mr. Stewart in for trial. We didn't ask to. Once we knew he was coming, we called him so we could question him. That's reflected in the second round of appeals case, but it's referenced in our current brief at page 14. We wanted to depose him. We didn't want him to come to. We said he couldn't testify at trial because, talk about collusion, why would transit ever produce a driver for deposition if they could just wait and bring him in at trial? So just to clear up the record on that, if that actually clears up with a very long record. The previous colloquy got into whether there's full cooperation under Public Officer Law 18, but I just want to make clear, Public Officer Law 18 should not apply here. It is the general statute that applies to any public entity that wants to adopt it, whereas Public Authorities Law 1212 specifically applies to public authorities, like the Transit Authority.
But did transit incorporate Public Officers Law 18 by virtue of the bylaws?
They tried, Your Honor, but we don't get to decide which laws apply to us. I can't say, you know what, I'm not going to be covered by this statute, nor can transit. There's no authority to repeal this statute. That statute is still on the books. The legislature, when it passed 18, did not repeal 1212. And if there's any other conflict, we have Public Authorities Law 1221, which settles it in favor of the Public Authorities Law.
And what about the point that this is against public policy to accept this assignment?
What, if I may put a rhetorical question forward, what is against public policy about promoting the enforcement of judgments, making whole judgment creditors, and ensuring that public employees are protected from liability for conduct in the scope of their employment? This is clearly supported by the law, and I say that makes a good policy. If there's nothing else. Thank you, Your Honors.
Thank you, Counsel. Okay, Werner.
Good afternoon, Your Honors. I'm here for JAG First Avenue, the respondent, and I apologize for possibly squandering the court's time here, but
You have a pretty good storm in progress defense.
I lost one of these where I didn't argue and the other side didn't show up, and so I'm a little.
So is it the failure to follow your own alleged protocol, is that actionable?
I'm a little hearing impaired, so I didn't understand
the
the question.
failure to follow your own snow removal protocol, which exceeded what's required by the city, is that actionable?
Not actionable under multiple appellate First Department holdings in Bai, Fang, Zhao, and one Mimikos and Prince. These cases, which they didn't even bother to attempt to distinguish two out of those three, all of which are deadly to their argument. They made an irrelevant attempt to distinguish I think it was the Bai Fang Zhao case by saying that something about how there was that the defendant caused the defect or the hazard here, whereas they didn't there, but missed the entire point that an internal rule, a failure to abide by an internal rule is not actionable, period.
Did your client have any notice of ice?
Excuse me?
Was your client on notice that there was an icy condition?
No notice whatsoever. My client had testified that there were no complaints. The plaintiff admitted that it was snowing all day, on and off, that it was snowing almost heavily at the time of the accident. And the certified weather reports verify that there was snow going on from 4:10 in the afternoon till 11:50 at least. So it was not very heavy, but it was significant through major parts of that period. So their argument about the internal rules, that we somehow rejected these rules because we were conscientious and the super would check up on the deli to make sure that their workers were doing a good job, that somehow that meant that we waived New York City Administrative Code 16123A, waived our rights under the storm in progress rule, makes no sense. They also argue, and they raised a couple of arguments in their reply for the first time, which are not valid arguments anyway, but one is that you need an expert affidavit, which is not true. A certified weather report is sufficient, and I could cite a couple of cases if the court's interested.
No, it's okay, counsel. I think we have your argument. Thank you very much.
Okay, thank you, Your Honors.
People versus Alfonso. Please.
Good afternoon. May it please the court, Alexandra Mitter on behalf of Jonathan Alfonso. In Antimarchy, the Court of Appeals held that defendants have a fundamental right to participate in jury selection. Now, normally, that process involves asking jurors a series of questions about their backgrounds orally in court, where those questions and answers would be translated for a non-English speaking defendant. Here, the court employed a sort of unique and unusual procedure where those very same questions and answers were given in writing. And they weren't translated for Mr. Alfonso, who is exclusively Spanish-speaking. This denied Mr. Alfonso his fundamental right to be present to evaluate the jurors' backgrounds and potential sources of bias.
Did trial counsel raise any objection to the procedure employed by the trial court?
He did not, and Antimarchy is quite clear that preservation is not required to raise this claim on appeal. And so, respondent, not surprising. Sorry.
Counsel, this is Judge Mendez. These answers were in a form. So the court passes up the form to the jurors who write their answers on the form, and then that form gets distributed to the prosecutor and to the defense counsel.
That's
that
correct.
The way it works?
Yes, that's correct.
So the defense counsel is seated at the table with the defendant, and there's an interpreter next to the defense counsel and the defendant at the time, correct?
That is correct, but I think importantly here, that is the procedure that was employed in the timeline, I think, makes it very clear that I think the suggestion you're making that perhaps the translator maybe translated those forms as counsel was going through them simply just could not have happened here. So the first time
Why is that? Why is that? Is there anything on the record that says that he didn't have a translator at the time?
No, he had a translator for things that were happening orally, but the problem here is that the forms were given, for the first panel of jurors, the forms were given Friday, last thing. They were distributed to the attorneys Friday, right before the weekend. First thing that happens when they walk in the morning is they start going through the jurors. Number one, ready for voir dire. Number two, ready for voir dire. There was no opportunity for the translator to translate those documents. The same thing happened with the second panel, where it was over the course of an evening. And similarly, the third time, the court called it a 15-minute break for everyone. And it's clear on the record that Mr. Alfonso was taken to a cell in the back of the courtroom during that period of time. So, put simply, there's absolutely nothing in the record that would allow this court to find that Mr. Alfonso saw what was on those forms, let alone had them translated for him. And in fact, the record really suggests quite the opposite.
Did the questions on the forms relate to potential juror bias or hostility on the one hand, or juror disqualification or disability on the other, or both, I guess?
Both, Your Honor, and that's why I think respondent's primary argument, which is that this was just about hardship screening, so this is not part of Antimarchy, entirely misses the mark, because these questions ask jurors about their employment, their spouse's employment, their adult siblings' employment, their prior jury service, their experience with the criminal system, their parents' experience with the criminal system, their friends' experience with the criminal system, whether they were friends with police or DAs. This is not hardship screening. This is the meat and potatoes of jury selection, and that is what always happens in the box. The fact that this happened on paper doesn't sort of change the nature of the questions that were being asked. And so
Were these questions also delve into once the voir dire commenced? Did the attorneys have an opportunity to question the jurors regarding the same questions that appeared in the questionnaire?
Sure. I mean, the lawyers in the court could ask the jurors, I suppose, any question they wanted, but the fact of the matter is that the questions and answers that were on the form were never translated in open court for Mr. Alfonso.
The ultimate result of that portion of the voir dire, it seemed like it was divided up. This was just to figure out who might not be available due to hardships, or if there was going to be some kind of consent or some reason that they couldn't serve. And then they went back through a more formal voir dire like you would normally have. And so I think it's sort of a follow-up. I thought that was sort of what Judge Mendez was also asking. Did they then ask these questions again and go through them and interpret them? Because now they got rid of the people that just couldn't sit, and now they were dealing with the people that.
They didn't, Your Honor. They did not go through each of those questions, and I think we provided a couple examples in our brief. For example, one of the jurors who was struck as a peremptory defense challenge, so one that the defendant really should have the opportunity to weigh in on, she did not come up at all during the sort of lightning round paper review, and she got asked 2 of those questions on the form. 2 of the questions on the form came up, and so Mr. Alfonso will never know whether his attorney decided to strike her because of one of the questions that he was privy to, having been asked orally in court, or something on the form. And there were so many questions on the form that he just simply never had access to. So I think, respondents' only argument here is that this wasn't formal voir dire. It's just simply not the case. There were hardship screening questions in the questionnaire, but the vast majority of questions in that questionnaire were the exact same questions that led to reversal and antimarchy that happen in open court. And the fact that they're on paper doesn't change the nature of those questions.
What's the strongest authority you can point to that this constituted this particular type of offense would qualify as an antimarchy type violation?
I think antimarchy itself, Your Honor, these exact same questions, whether you have friendships with police officers that may potentially impact the way you view police testimony. That's what happened in antimarchy, and that's exactly what happened here. And the fact that Mr. Alfonso never got to hear whether juror number 37 had friendships with police officers, he might have wanted to tell his attorney to plumb the depths of that a little bit when they were actually in the box, but he had no idea the answer to that question in the first place.
Thank you, counsel.
Good afternoon. May it please the court, Maria Wager for the Bronx District Attorney. Defendant's claim is meritless. He was present for every single second of this trial, and he does not contend otherwise. And his claim is needs to be supported by things that are clearly divorce the record.
We know it's from the record that he required a translator at trial, correct?
He did, Your Honor.
So we know that.
You know that he needed a translator. We don't know whether he can read any English. We also don't know that the attorney did not sit down with him, have his own translator, and go through these forms. As my adversary conceded, there was a break after the forms were dispersed to the parties. And the parties agreed they had enough sufficient time to go through the forms. So the defendant is asking this court to assume that nobody reviewed these forms with him. Also, as to Your Honor's questions, the defendant was present for formal voir dire. The forms did delve into hardship as well as more of, as my adversary termed it, the meat and potatoes. But that meat and potatoes was then delved into with the defendant present at all times.
So is it that if there was a pure antimarchy violation at the challenged stage reviewing the questionnaires, it was obviated by what subsequently occurred during voir dire?
Yes, Your Honor. The defendant was present for the formal voir dire. Only jurors that were dispensed with where there wasn't more additional questioning was for hardship type disqualifications. Defendant was present for the formal voir dire. He never objected to this method. It's not an unusual method at all. He never objected. In fact, he agreed to it. Counsel always said that had enough time to review it. And so it does need to be preserved, and it's not preserved, and it also needs to be supported by facts that are divorced.
Well, I mean, so are you suggesting that maybe there should have been a motion based on ineffective assistance of counsel because of the way the counsel handled the situation, when you're saying it has to be supported by something to hold the record?
I'm not suggesting that there was indeed ineffective assistance of counsel.
Right.
What I'm suggesting is that defendant is making a masked ineffective claim because in order for his claim...
That's what I'm asking, that if she wants to pursue that, she might need a different type of proceeding before us.
Definitely, Your Honor. That counsel did not review the written questionnaires with defendant. And we have no evidence of that. In fact, to the extent that the record does support it, counsel agreed that he did. And so, would have to ignore that. And if there are facts where defendant feels that he that did not occur, then that would have to, the vehicle for that would be a post-verdict motion, collateral motion. Okay. Okay, if there's no further questions, the people will rest on their
Any
brief.
further questions? Thank you.
Thank you.
To pick up where we left off, a post-conviction motion is not necessary here because counsel didn't have to object because no objection is required. And Mr. Alfonso never received an antimarchy instruction that he could have waived in the first place. So there was no record to be made there. And in terms of the questions and answers that happened in the jury box after these forms were completed in writing, that would only obviate the problem if it constituted a de novo hearing on those same questions. And the only way it's going to be a de novo hearing on those same questions and answers is if those same questions and answers get asked. And that's simply not what happened here. It's respondent suggesting that we're asking this court to speculate, but it is really respondent that's asking this court to speculate. And I just want to be clear, speculation is kind of always baked into antimarchy violations. There's always, well, maybe the defendant could hear what was happening at the sidebar, or maybe defense counsel came back and told defendant what happened, or maybe defense counsel shared his notes. This court has repeatedly rejected those types of speculation, and that's exactly what respondent is asking the court to do here. And I would just direct this court to Williams, which is at page 30 of our brief, to deal with that issue directly. Thank you.
Thank you very much. Thank you both. Kodayan versus Kassir. Please, counsel.
Good afternoon. My name is Elliot Zucker from Aronson, Rappaport, Feinstein, and Deutsch on behalf of the defendant's respondents. From the time this action was commenced until the time we moved for summary judgment, the plaintiff was operating under only one theory. The theory was that his client and my doctor had come to an agreement to do a two-part procedure, one of which was a rhinoplasty, the other was septoplasty.
Right. And the complaint says the septoplasty wasn't done?
And the original claim was that the septoplasty was not done.
And the first time you heard about the possibility the septoplasty was done improperly
was in response to our summary judgment motion. Okay, and the case the court certainly knows and has from my brief, there's plenty of case law that says you cannot change your theory in response to a summary judgment motion. And this is important. There's a big difference between combating a claim that says nothing was done versus combating a claim that what the plaintiff turned this into is whether it was properly done. Okay, that's a big difference. And you simply, not only don't you get to do it under our law, you certainly don't get to do it through the affidavit, through an affirmation of an out-of-state doctor, which is inadmissible.
Speaking of the breach of contract claim, is it clear that no specific promise was made, as you say, or did the parties have some sort of agreement that...
There's ample evidence that no specific promise was made from the plaintiff's own mouth. First of all, the plaintiff's pleadings expressly state that no promise was made. Second, the plaintiff herself testified repeatedly that no promise was made. She said she knew there was no guarantees going into this. And she said, I mean, the most telling example is, I think on page 575 of the brief, she says, look, my problem here isn't with, I didn't know the risks, I knew the risks. The problem wasn't that there was a guarantee that was breached. I knew there was no guarantee. My problem here was that one procedure of the two wasn't done, okay? Of course, we now know that that's wrong. One of that procedure was done. And again, the plaintiff may want to turn this into a debate now about whether it was done sufficiently, which is an entirely different question, but that was not the premise of the lawsuit up until summary judgment.
Well, let's assume we're going to consider the quote-unquote new theory.
Mm-hmm.
What is the deficiency or fatal weakness in Dr. Busaba's affirmation/affidavit?
I would say they still have a tremendous problem with causation here. And let me pause here for a minute, because I believe I made an error in my reply brief. I believe I said that in the subsequent surgery, that no part of the septum was removed in that subsequent surgery. That's incorrect, and I apologize for that.
Right, it was a submucosal resection of the
Well, the second procedure, though, was focused on the sinuses.
Right, but there was something done to the septum.
Right, right. But so my point, I mean, it's not, I don't think it's.
It's clear from the record
Mr. Cohn
that
thinks it
happened,
is.
yeah.
But
But an SMR is a much more involved procedure, is
it's
it
a
not?
much more involved procedure. Very notably, Dr. Kassir did not have consent to go anywhere near that area, okay? And the plaintiff's expert, to get to your question, he very carefully words his affirmation. He says that as a result of the failure to remove enough of the septum, he had to remove more. But what he doesn't say is that this would have stopped the plaintiff's problems without doing the sinus surgery, something that my doctor was not authorized to do in the first place. Okay? We've already discussed the breach of contract claims. Again, the informed consent claims are very confusing.
Well, let's talk about the informed consent on the day of the surgery. I looked at this point, the part of the record that supposedly embodies the consent, and I didn't really see a consent form. I saw a bunch of forms, but I didn't see a consent form. Do you have a record page number for that?
I'm sorry, I do not with me. But again, let me add that the plaintiff herself said repeatedly she knew the risks of the procedure. Okay, and what's interesting about all the plaintiff's position is that he never identifies any risk or alternative that he says that my doctor should have told the plaintiff about that he failed to tell her about. How can you have an informed consent without an identification of the risks that should have been informed that weren't?
Well, I guess that goes, though, to your prima facie showing in the first instance of whether an informed consent was given, which...
Well, again, I think we make out our prima facie case through her own testimony, that she knew the risks. And she said it in multiple places, okay? Besides the page 575, which I mentioned before, you could go to page 461. She says, I knew the risks. Okay? That then leaves, I think is the only other issue, the forgery claim. This claim is also very strange.
I mean, I suppose it could both be a forgery. In some world, it could be both a forgery and the software malfunction that you describe. In other words,
Well, I think what the plaintiff is now trying to do with their
awkwardly
new
do a
theory
forgery
is
and-
relate the alleged forgery to the lack of informed consent. But again, she says she knew the risks. It's strange. Forgery is a species of fraud, okay? Here, there's no claim of any reliance. The supposed forgery took place well after the events in question. There's no showing that Dr. Kassir himself had any involvement in the preparation of these documents. So the claims against him individually with regard to forgery should be out. And more fundamentally, if I can just finish the thought,
please,
is that the plaintiff has a separate section in his exhibits of the pages that where he says that these are questionable signatures. But if you look at those signatures and look what's on the page, how does that advance any interest of the defendants? It doesn't show anything.
Thank you.
Thank you.
May it please the court, I'm Steve Cohen of Paula Cohen on behalf of the plaintiff respondent. The defendants are unhappy with Justice Kelly's rejection of their summary judgment motion. They also said in their papers he took a who cares, quote, who cares attitude towards this case. And they're challenging him that he erred in two ways. First, that he allowed our expert testimony in, our expert reports in, despite what he called a short delay in an expert exchange. And secondly, he erred because he rejected the arguments that there were no genuine issues of material fact to go before a jury. And I'd like to address both.
Maybe we could bypass the former and go to the latter.
Forgive me.
Maybe we could bypass the former, the procedural concerns, and go to the substance, at least for the moment.
Happy to hear. Justice Kelly wrote a 41-page opinion. He quoted the experts, Dr. Hallis on their side, Dr. Busaba, Dr. Nadiri, and Mr. Ozowski, the handwriting expert. He weighed them both.
he identified more than a dozen genuine issues of material fact. And that's what's before this court, not to decide, unless you wish to go into which side had the better argument, assessing the credibility. That's for a jury. What we are asking, this case has been going on for 7 years. It's scheduled for trial.
Counsel, on the conformed consent issue, I believe you say in your brief that you're conceding that she did sign informed consent on the day of the surgery. You're just saying perhaps that was rushed and therefore not operative. Is that correct?
Exactly. It's not only rushed, Your Honor, it's what Dr. Ndiri says is inadequate. She was in a hospital gown. She had an IV in her arm. She was being walked into the surgical suite. And they put a form in front of her, and she signed it.
She did sign an informed consent form. Okay.
And it said rhinoplasty. It didn't say septorhinoplasty. And what she agreed to have done, and she was very clear with Dr. Kassir about this, I will only do the surgery if you address both things. There was absolutely a cosmetic piece to this.
Right. She was happy with the cosmetic piece, so that's not an issue. That's not an issue.
She loves it.
But didn't the septoplasty go forward that day?
Not at all.
Not at all?
Not at all. He took out a 4-millimeter piece of the septum. That does not qualify. If you look up any definition, our experts will say and will testify that is not a septoplasty.
What about Dr. Loft, the doctor who did the subsequent surgery? He seemed to say that, yes, something happened there that day. There was a septoplasty.
But he also told her that no one ever gave you a septoplasty. And counsel was right. They made a mistake in their reply brief, more than one. But they said, and I'll address the second one if I may, that Dr. Loft operated on the septum. He took out a 5-millimeter spur from the septum. He took out turbinates from the nasal cavity, and he addressed the problems in the sinus itself, including a 1-inch polyp that he took out.
Well, but that wasn't something that Dr. Kassir agreed to do, right?
He did, though. He asked for permission, in fact, in the informed...
To go into the sinuses. He asked
for permission. In the informed consent forms that are in the record, it says sinus ENT surgery. First page of the informed consent forms that were done on January 19th.
The electronic ones that you say were a forgery.
Which we think are forgery. And we think they put them in as they have already admitted there are false signatures in the record. They allege that those... I'm sorry, Your Honor, you're about to say?
No, I just was wondering how your client is prejudiced by that forgery. How is she prejudiced?
She would have never agreed had they said to her, we are only going to perform a rhinoplasty. She would have never agreed to the surgery, ever. And she testified to that from the beginning. In the meantime, they forged the record to cover up what they didn't do, and Judge Kelly says that in his decision. Was this done to cover up what was not done? That is an issue of fact to go before a jury. We have to prove causation. I agree. But it's not a decision on summary judgment.
Can I ask you, counsel, in reference to Mr. Zucker indicated that you changed your theory on this case. Could you address that, please?
We did not, Your Honor. She said originally, I went in for this combined procedure, and Dr. Kassir said to me during the first consultation, it may not be the septum that is causing this chronic breathing problem, but when I open you up, whatever it is, I will take care of it. That's what she agreed to. And the theory is, from the very beginning, he never did a thing to address the breathing problem. In fact, in their papers, they say repeatedly, a rhinoplasty and a septoplasty. I'm sorry, Your Honor.
Removing the 4 millimeters of cartilage, wasn't that addressing the breathing issue? Sort of like the septoplasty that we've been talking about?
They argue that it is, Your Honor. We argue that it is not. It was moving the septum 4 millimeters. I can't even keep my fingers that small. But that did not affect the breathing problem, address the breathing problem whatsoever.
So taking that argument on his face, isn't your argument then that whatever he tried to do was not sufficient enough?
Argument is he didn't try to do it.
Would then be a change in your theory of the case?
No, Your Honor. Our theory is he never tried to do anything to address the breathing problem, because if he did, he would have seen the turbinates in the nasal cavity itself. He would have seen the septal spur on the septum, 5 millimeter, which Dr. Loft did take out 2 years later. He didn't do anything to address the breathing problem. He did a great job on the cosmetic nose job.
Sir, could you?
What's the reason for removing the 4 millimeters then?
I'm sorry, he straightened it, Your
The
Honor.
reason-
I apologize.
The reason for removing the 4 millimeters.
It was totally
not-
cosmetic. He took a bump off her nose, and he recommended that she have the tip of her nose upturned just a little bit because it drooped when she smiled. That part had nothing to do with the breathing, it had everything to do with the terrific job he did on the cosmetic portion.
Sir, would you mind just addressing your friend's point about, in his view, there's the opinion, Dr. Busaba's opinion relating to proximate cause was not sufficient to raise a triable issue of fact. Would you mind addressing that point?
I think, Your Honor, that Dr. Busaba's position was that Dr. Kassir did not attempt to do anything about the breathing. If he had done it properly, he would have done a CT scan, he would have done a endoscopy, which he didn't do. He literally looked up her nose with a light. He never did the basic diagnostics, and then he never addressed what was her principal cause. One of the two things she said on all the forms and in the interview when she met with him on that first day, I have a chronic breathing problem. Other doctor has diagnosed it as a deviated septum, to which Dr. Kassir said, it may be, it may not be, but we'll find out. And his failure to address anything was the proximate cause of her having to go for a second surgery, endure a second intubation, endure general anesthesia 2 years later with Dr. Loft. It was the proximate cause of her injury and of the damages.
Thank you, counsel.
Thank you, Your Honor.
Just very briefly, I think there's some, I hate to call them word games going on here, but the reality is we went from a claim that nothing was done to a claim that 4 millimeters was insufficient. That's different. Nothing is different than 4 millimeters being insufficient, okay? One is that no septumology was done. The other was it was done, but it wasn't adequate. That's a new theory.
It wasn't done to extraordinarily incomplete. That's...
Yeah, exactly. It was from not being done at all, which is, again, why the plaintiff herself says the lawsuit was brought, to you didn't do it well enough.
What do you call the removal of 4 millimeters of the cartilage in the septum? What do you call that? That removal, the 4 millimeters?
I call it a septumology. I call it exactly what they agreed to do.
Plaintiff says that it wasn't enough to be called that. I don't know if there was
and that's
any...
why I said I don't want to, I don't want to verge into semantics games, but there's still a difference between nothing being done and something being done.
What did Dr. Busaba say on this score?
He said that more should have been done.
And you heard your friend's response to my question about the sufficiency of his affidavit vis-a-vis proximate cause. Do you have any follow-up with that?
And again, I say you'll note very carefully how he doesn't say that the problem would have been solved with just removing more of the cartilage. It required a different procedure, which Dr. Kassir was clearly not authorized to do.
Well, if I understood your friend correctly, if Dr. Kassir did all that he held out that he would do, plaintiff wouldn't have had to endure a second surgery.
But I think if you look at the plaintiff's expert, again, assuming it was even an admissible form, what he really says is that because he didn't remove enough, the next treating doctor had to remove more. He doesn't go so far as to say that that would have relieved her problems without the further sinus surgery that my client was not authorized to do.
Thank you very much, counsel. Thank you both. Okay, McGovern versus St. Luke's Roosevelt. Now, I'll tell you why. Counsel.
Hello again,
Welcome
Your
back.
Honors. May it please the court, Christopher Della Carpini for the appellants, Mr. and Mrs. McGovern. So Justice Frank granted summary judgment on two grounds, the first of which was on the vicarious liability issue. He reasoned that this all started when defendant's paramedic, Mr. Correa, shoved this already aggressive patient. He then reasoned that, well, shoving a patient isn't part of a paramedic's job description. Therefore, shoving a patient is never within the scope of employment such
Is it never, though? I mean, we all saw the videos. There's a very cramped space. You know, he was dealing with an emotionally disturbed person. There's going to be physical altercations between emergency medical technicians and such people, and emotionally, unfortunately, that's going to happen. So isn't that part of the job? Wasn't it within the scope of his employment to at least defend himself or create space between him and the emotionally disturbed person?
Oh, I agree it was. Everything he did was within the scope of his employment. I think that's a common sense conclusion. I think if you apply the Court of Appeals decision in Riviello, which we discussed at length in our brief, and which the respondents completely ignored, you show that this was in the scope of his employment. However badly he was doing his job, if he was doing his job, then vicarious liability can attach. The circumstances are obvious. They are there responding to a 911 call, as are the firefighters. The patient does not become aggressive until he gets the sternum rub and he gets woken up. He doesn't attack until he's shoved. And we have the other paramedic who testifies that, no, you don't shove a patient. There's a whole set of protocols about how you keep a safe space in a confined area like that as best you can. And they all agreed, you're never supposed to shove them. But however badly you do your job, if you're doing your job, vicarious liability will attach. Certainly, at least an issue of fact. We're here on summary judgment. It's at least an issue of fact as to whether Mr. Correa was acting within the scope of his employment. The other basis on which Justice Frank granted summary judgment was causation. He looked at this, I assume he looked at the video, and he found that either the patient was a superseding intervening cause of the injuries here, or Mr. McGovern was the sole proximate cause of his own injury.
On that point, just staying on proximate cause, what are we to make of the FDNY report? It's an injury report that says the EDP acted without warning. Does that mean that he's an intervening cause?
No, because the crux of the causation issue here is foreseeability. And I submit
Which is usually something we leave for a jury, right?
Of course. Yes. This is, again, deciding unforeseeable as a matter of law. I submit it is not unforeseeable that an already agitated patient will react as this patient did when he gets shoved. I also would submit it's not unforeseeable that a firefighter on the scene would interpose himself to protect everyone. That's why they're called New York's bravest. They get in the way of things like this. And on the sole proximate cause issue, I submit the video does not show that Mr. McGovern punched himself in the nose or that he dragged everybody down on top of him to break his ankle. So I would say at least on those two grounds, if there's any evidence to support either of those theories, there's an issue of fact for the jury. The last thing I'll say on the issue of Mr. Correa's liability, which would be a basis for vicarious liability, Justice Frank did not address that at all, which I think indicates that it's at least an issue of fact. But I think the danger invites rescue doctrine makes clear there's a basis for vicarious liability from the beginning.
Yeah, well, on that one, though, did you make that argument on danger invites rescue below?
No, it's not in the papers below, but this is an argument that if it had been made below, Justice Frank would have had to address it. It's not clear to me that this court could grant summary judgment on a ground that was not raised in the papers below. But if this court is of a mind to consider whether Mr. Correa is liable such to be a predicate for vicarious liability, I would submit the danger invites doctrine at least raises an issue of fact on that point. If there's nothing else.
Any other questions? Thank you, counsel.
Thank you, Your Honor.
You have rebuttal.
Good afternoon, Your Honors. I'm Judy Shametzi with Wilson Elster for the respondents. I thought it was interesting that the plaintiff would raise at this stage, but still the danger invites rescue doctrine, because it would turn for that doctrine to be applicable, aside from the fact that it is belatedly raised and shouldn't be considered. But the tone of it invokes a type of conduct that puts another person so much in danger that a third-party rescuer has a reasonable fear that they are in imminent risk of serious harm. And the idea that you would even formulate that argument and at the same time claim that this person is acting within the scope of their employment, which is to render medical care, I think that those two concepts are not compatible. I will say that from the papers, perhaps it's not as clear, although it became pretty clear to me from the plaintiff's deposition testimony and abundantly clear from the video. And I do implore the court, if the court has not seen the video, to watch it, because I think the tone of the altercation becomes quite clear, and I think the personal animus between the EMT and the patient becomes clear.
Well, the videos are very short, so you don't know everything that happened before the
Sure.
push came to shove, as it were.
Well, but it does show just that moment.
It shows a
where
push,
push
yeah,
comes
it
to
does,
shove.
but that's going to happen, is it not, counsel? I mean,
sorry, Your
isn't there an issue of fact about whether the EMT worked outside the scope when he was pushing back and even punching the EDP?
I don't believe there's any issue.
If he's punching,
I don't believe there's any issue there, Your Honor. I think that this is clearly not a function. The way that he is interacting with this person and the way that he is treating this patient is not in furtherance of the medical care that he is dispatched to
Is
provide,
some
and he is
contact
clearly.
between an EMT and a patient foreseeable?
There would be circumstances in which that would be foreseeable. There would be circumstances in which that would be proper and necessary. This is not.
Okay,
one of
so
those
now I'm just reading from the Court of Appeals in Rivera. In some cases, particularly those involving occupations for which some physical contact with others is permissible or even expected, okay, it may be difficult to determine whether a challenged action falls far enough outside the boundaries attendant to the employment relationship such that the employee should be solely liable for their respective tortious conduct. In those cases, where the question may be one of degree and not kind, the vicarious liability issue is appropriately left to the fact finder.
Correct, Your Honor, and I agree that there are some cases where that's true. Here, this is, again, based on the video, based on the plaintiff's description of the interaction between these two individuals, I do believe that this falls far outside the gray area. I do believe that the interaction here is of a personal animus. I do believe that it is not medical. What these two are doing is not a patient.
This was a
EMT
very,
medical.
very short video.
It
I mean,
is.
there were two videos. I think one was 11 seconds,
both of
one
them
was
are very
15 seconds, and you know, there was no sound. At least when I heard it, there was no sound. Watched it, and it's you know, it's difficult to glean everything from it. But I mean, I'm thinking you're talking about with the personal animus and way above. I'm not sure I can figure that out from, and I watched it a few times.
Yeah, I do think, Your Honor, that in conjunction with the plaintiff's deposition testimony where he describes that the CMT came in and this remains the plaintiff's theory now, is basically baiting this person, right? The plaintiff says, look, we all know that some patients get like this, some people get like this, and we treat it as, you know, we let it roll off our back, we step back, we let him do, but this CMT basically got in his face. Instead of backing off, he took up the fight, and that is absolutely not the role that he was there to perform. That is not poor job performance. That is a reaction to the situation he is encountering where he is not acting as an EMT. He is acting as a person who is responding to the aggression of this individual in a way that I do think is personal.
Isn't that something that is subject to interpretation, which would be better left off to a jury to decide?
In this circumstance, Your Honor, I would argue it is not, based on the plaintiff's own description of what is happening, the plaintiff's own description of what this would look like if this were medical care, and what this interaction actually looked like with this particular EMT.
But that's not what the EMT said, which is also something that has to be considered.
Well, yes, the EMT describes, first of all, does not own the fact that he at a minimum continued to fuel the conflict, which, as short as the video is, that much is clear. But also, I think it's interesting the way that he describes the patient, which is in very much in a language that I would expect to hear from a layperson who is all of a sudden attacked by somebody who they fear, which I think is clear from his testimony. And I think that that's what we're talking about here, and that's not what he's there to do.
Thank you, counsel.
Thank you, Your Honors.
Your Honor, I think counsel makes a very good point that the distinction between whether this conduct was within or without the scope of employment is personal animus. Because let's look at the circumstances that brought these two people together that night. The only reason the paramedics or the firefighters are there is because of a 911 call about this patient. There's no personal reason for Mr. Correa to be there. There's no reason for any of them to be there except for doing their job. Their altercation does not begin until Mr. Correa revives this patient, which he's doing as part of his job. And the altercation happens after that within the space of handling this now aggressive patient. Mr. Correa doesn't have some grudge against him, and there's no evidence in the record of that. There's no evidence they even knew each other. There's nothing personal there. He's there doing his job. He's doing a poor job of his job, but he's there for his job. And that's what makes this within the scope of his employment, at least to an issue of fact level that makes summary judgment inappropriate at this point. If you can see personal animus on either of those videos with such clarity that there's no dispute, then you should affirm. But that's exactly the kind of thing we have juries for. If there are no further questions, thank you very much.
Thank you. Thank you both. Okay. Board of Managers of the 443 Granite Street Condominium. Please, Counsel.
Good afternoon. My name is Cole Munson. I'm with Woodsmith, Hennedy, and Berman, and I'm for the appellants. We are seeking to dismiss the plaintiff's claims for breach of fiduciary duty and for constructive fraudulent conveyances. Starting first with the breach of fiduciary duty claim.
Let's start actually with another thing, which is that there's an amended complaint in this case, correct?
Correct.
And there's been a ruling below by Judge Cohen concerning it, correct?
Correct.
There's an appeal on that ruling that's coming up next month, right?
That is correct.
So don't you see that as a problem? Because once the plaintiff files an amended complaint, doesn't that become the operative complaint in the case? And so why are we here arguing about how some of the claims are cited in the original complaint if it's been superseded by an amended complaint with an appeal coming up in a few weeks?
Well, the amended complaint doesn't affect the claims that are being addressed here. I also sought to join them, but both appeals. But
you made a motion?
Yes. I requested the information regarding the process, and I was told to proceed with them separately. But in any event, I don't believe that there's any different. I believe that the claims that are discussed in the amended complaint are unchanged as are addressed here today.
The way I saw it, the debtor-creditor claims in the amended complaint were not the same as the ones that there was a difference in what was pled, different sections and whatever.
Well, they did plead DCL section, the former DCL section 279 in the amended complaint. But
and there was a motion to dismiss that, and Judge Cohen denied that.
Correct, but not on the grounds of whether it was. We did not move to dismiss the claim based on whether it was mature or not, which is what we address here today in connection with the former 278 claims.
So the mature question is moot. Is it?
Well, they're still making an allegation, or they're still asserting the former DCL 278 in the amended complaint.
Which does involve some aspect of maturity?
Correct. The former DCL 278 relates to solely to claims which have matured, and allows for a party to have conveyances set aside where the claim is matured, i.e. a judgment has been taken against the conveying party, which here it's undisputed that that is not the case. And the cause of actions brought here today regarding the constructive fraudulent conveyance claims are dependent on.
What about the breach of fiduciary duty claim in the second order that you've appealed? Is there one, I mean,
We did not appeal in the subsequent order, which is going to be addressed last month. We do not address the breach of fiduciary duty causes of action because those allegations were unchanged.
So we've got the original complaint and the amended complaint are substantially similar or identical with respect to the breach of fiduciary duty. And the amended complaint has new or augmented allegations with respect to the debtor-creditor law claims?
Correct.
Okay.
Then again, since we've addressed the constructive fraudulent conveyance claims, I'll again focus on the breach of fiduciary duty claims, which are not addressed in the subsequent appeal, so you don't have to hear that again next month. But regarding those claims, we mainly seek dismissal based on the fact that the business judgment rule should have been held as applicable as to the claims asserted, or the allegations of breach asserted against the individual appellants. Those claims.
But doesn't that defense have to be unpacked in discovery? I mean, this is a pleadings motion, of course.
Correct.
And so doesn't there need to be some discovery about the business judgment rule?
I do not believe so, and I'll point to the Latitude Riverdale condo case, which
was after a summary judgment motion.
It was, but it was not decided because.
See, the problem is that you've got here a case of, alleged self-dealing by the sponsor board members. And so, you have to unpack that a little bit and find out if they have justifications for some of the things they agreed to pay out of common charges, So, or that enrich, I mean, there's a lot of things that are going on here that are factual. And so therefore, just looking at the complaint as it's written, it seems like they've got, at least they've pled a breach of fiduciary duty claim.
Well, as if I'm focusing just on the Latitude Riverdale condo case, the decision was based on the allegations that the individual owners acted in bad faith, in that they they prioritized their own interests over the interests of the condo because they were associated with the sponsor, and they failed to reserve sufficient amount of funds for repairs.
Right.
The court did not say that the court did not hold that the plaintiff failed to establish these claims. It just said, just based on those pure allegations, that is insufficient, or that would be barred by the business judgment rule. So the fact that it's before, it's at the pleading stage or it's at the summary judgment stage should make no difference because the focus again is on the allegations. And the allegations, which here are that relate solely to expenditures for repairs and maintenance, are barred by the business judgment rule. So there's nothing that would be, if it's based on those allegations, even if they prove that with discovery, it would still be barred by the business judgment rule because, again, it relates to the individual appellant's decisions as it relates to repairs and maintenance to the condominium. Also, quickly, I'll go to address the breach of the statute of limitations issue. A 3-year statute of limitations should have been applied, and if correctly applied, the claims as against appellant Freed should have been dismissed. We just submitted documentary evidence establishing that as of August of 2018, he was no longer serving as a member of the board. The complaint was served more than 3 years later in December of 2021. As such, it should have been dismissed.
Thank you. Counsel.
May it please the court, my name is Nathaniel Benfield of Hogan Lovells US LLP, appearing on behalf of plaintiff respondent. So I'd like to start with the fact that the appellant here is misrepresenting our factual allegations with respect to are breach of fiduciary duty claims.
How does the situation in this case distinguish from the case that he is relying on, where he says, well, they were just dismissed? I mean, what makes this any different? We know that the business judgment rule is used very, very frequently, and the board does get a lot of passes, but how in this case, is it the allegations of fraud? What is it that puts this case in a different position?
Yeah, so I believe you're referring to the Latitude Riverdale,
Yes, the Latitude
case. And it's our position that the business judgment rule cannot be applied to allegations of conflicts of interest, bad faith, or fraud. There's a number of cases that have ruled that way. The Board of Managers of Latitude Riverdale condo case, that's simply a case where those, again, as you guys noted, that's on summary judgment.
Right, I understand.
And
they didn't say too much. I mean, there wasn't too much discussed in that decision.
At the First Department level, that's right. If you look at the Supreme Court's decision in that case, it explains that the plaintiffs in that case just simply failed to prove those items. So, and I'll quote the Supreme Court. The Supreme Court explained, quote, that the plaintiff failed to establish that the individual defendants engaged in self-dealing or fraud, acted in bad faith, or acted beyond the scope of their authority under the bylaws. And that's what drove the decision in that case. So just because they failed at their opportunity of overcoming the business
You've at least stated it and are going to try during discovery to prove it.
That's right. We're going to need discovery in order to prove our point there. That's right. Yeah. And so one thing that sponsor said in his papers, and they said just moments ago, is that our allegations are just challenging the amount spent on repairs. And that's simply not true. What we're alleging is that the sponsor's principals made the unit owners pay for the cost of constructing the building,
Right.
but that the sponsor did not have to.
That came out in your papers.
Yeah.
Okay, great.
Like the sprinkler system, for example, should have been paid not as a construction cost, and it shouldn't have been paid by common payments.
That's right. And that distinction between what we actually allege and what sponsors claiming we allege is important because it explains why we overcome the business judgment rule. It also explains why a 6-year statute of limitations applies to this case, because there's elements of fraud in those allegations.
Can
Also,
you?
I was going to ask about the procedural question.
That's what I was going to. Okay, go ahead.
Can we even deal with the with this claim? I mean, is this a moot appeal?
I believe it is a moot appeal. I mean, there's a reason for the rule that the amended complaint takes precedent. One of the reasons is for efficiency, and the way that this was handled, we now have to all come back in consecutive months. So I think that would be proper grounds for denying.
But in the second appeal, I gather the fiduciary duty claim is not raised. It is raised here. It's not raised in the subsequent appeal, correct?
That's correct.
The debtor-creditor law, it's a whole new ballgame. I mean, one could say.
Their motions to dismiss with respect to the debtor and creditor law are now split across 2 different motions. And on this motion, it only relates to the fact that we reference Section 278, which it provides the remedies for unmatured claims, whereas Section 279 provides the remedies for matured claims. This argument has a couple of issues with it. First, we were not required to allege that our claims matured. That is not an element of a constructive fraudulent conveyance claim.
Wait, are we going to the allegations in the amended complaint, or are we talking about the underlying complaint? Because really, there ought to be only one at this point, but we seem to be operating under the, indulging the fantasy here that there are 2 for different reasons.
I know, and it's difficult to keep track of both at the same time, but in this respect, this constructive fraudulent conveyance claims are our only claims against this set of defendants. And constructive fraudulent conveyance claims do not have an element that you have to allege that they're matured or unmatured. The DCL permits claims by creditors regardless of whether the claim is matured or unmatured, and that's made clear in the text of the DCL. The definition of creditor includes both matured and unmatured claims. Sponsor's argument is really a hyper-technical argument, based on the fact that the original complaint references DCL Section 278, but not 279. If that argument has any value at all, it's clearly made moot by the fact that our amended complaint references Section 279.
So is your friend correct that your amended complaint is the same or substantially the same as it relates to the breach of fiduciary duty claims?
We did not add any allegations relating to that.
So you just took out some of the paragraphs in the causes of action that Judge Cohen had ruled should be taken out, and you didn't, and
we took out the causes of action that they said to take out. We also added allegations against other defendants for constructive fraudulent conveyance and actual fraudulent conveyance, and some additional allegations with respect to solvency, which relate to this defendants, but the way that they did their appeal papers, it doesn't relate to this appeal. If there are no further questions, I'll rest my papers.
Any other questions? Thank you. Please.
I'll just now also turn again back to the Latitude Riverdale condo case, but I now want to talk about the issue of the breach of fiduciary duty claim being duplicative of the breach of contract claim. While this wasn't addressed in the appellate's decision, it was also addressed in the lower court's decision, and it denied on that ground because it found that the breach of fiduciary duty claim was merely duplicative of the breach of contract claim. Here, as I set forth in my papers, if you compare the allegations in the complaint, which are also the same allegations as it relates to breach of fiduciary duty and breach of contract claim, they're identical in the amended complaint. And they reiterate the same allegations. It's that the sponsor entities breached the offering plan by basically failing to renovate.
Very similar allegations. What's different about it, I guess, is the status of the individuals involved. So that it's their status as board members that invest them with fiduciary duty. So that's the difference.
And that was the lower court did address that there was a conflict of interest based on the fact that they owed a duty to the condo, but also the fact that they had their own interests in the sponsor entities. Of course, again, going back to the Latitude Riverdale condo case, the same issue existed there, and that did not bar the application of the business judgment rule. And if we want to now turn even further to the Fesco case, which is cited by the respondent in opposition, that's a completely different scenario, and they use the word conflict of interest, but it's really relating to self-dealing in a context where an individual was leveraging corporate assets to buy out his brother's shares of the condo or of the business, and he also falsified the corporate books. Completely different scenario than what we have here, and again, as in the Latitude Riverdale condo case, there was a fact that there was a conflict of interest did not stop the court from applying the business judgment rule. Thank you.
Thank you, counsel. Thank you both.